Welcome all back to the sessions. We are continuing with Mr. Anand Krishnan. Mr. Krishnan is a manager at Policy and Data Security Council of India. He is working in the domains of technology policy with focus on data privacy, cybersecurity, and cross-border data flows. He has studies from Vrije Universiteit of Brussels, the National Law Institute University, the University School of Law and Legal Studies. Mr. Krishnan, thank you so much for being here today and addressing our students. The floor is yours.
Thank you very much for having me. Good evening and I guess good morning to the attendees. I'll just quickly share my screen. Yeah, that's a good question. Is everybody? Yeah, okay, great. Can you see my screen?
Yes, Mr. Krishnan, it's viewable.
Okay, great. So thank you very much for having me. I hope by the end of this session you will have a general overview in terms of the privacy landscape that is there in India at the moment and what it looks like in the future. And also to sort of those who are unfamiliar with privacy as a domain, I know a lot of students have joined this session and the training program, to also highlight that this is an upcoming area as something that people from legal as well as the technical domain should look to explore in the future in terms of employment or in case of research opportunities. So as I was introduced, my name is Anand Krishnan. I lead privacy and public policy at DSCI, and DSCI has been involved in the privacy debate conversation in India for a very long time now, say about 12 years or so. Very recently, we were also part of the Justice Krishna Committee, which looked at the deliberations around the formulation of a personal data protection bill for India. So the way that I've structured the discussion today is I'll take you through what we have at the moment in India. Then I will take you through the privacy bill, which was tabled in the parliament last year. We'll take these questions at the end of the discussions. Say we'll have 10 minutes earmarked at the end, and we'll take the questions as they come. And if I see any, I'll also intermittently pause where I feel like there should be some questions coming up. I'll also pause and may ask a few questions. So thank you very much. So I think the overall conversation in India really started to heat up when we had the Justice Puttaswamy judgment of the Supreme Court in 2017. What it really did was it reaffirmed the existence of right to privacy as a fundamental human right. And this is something that brings us very much in line with different privacy legislations that we see, especially in the European Union and some other countries that recognize privacy as a fundamental right. GDPR, as well as you may be aware, derives a lot of its value from its express recognition of privacy as a fundamental human right, as well as data protection as a fundamental human right. So the Justice Puttaswamy judgment recognized that the right to privacy is a fundamental right. So the way that I will describe privacy is that privacy is a larger circle, right? In which you have bodily privacy, your communication privacy, and other aspects of privacy. But within this larger circle of privacy, there is a smaller subset known as information privacy or data privacy. So all these conversations around any sort of privacy laws, any sort of implementation around privacy laws and their interpretations comes into the picture when we are discussing information privacy or data privacy. What this data really is and what segment or what part of data as a larger concept are we going to look at is something that I'll cover during the course of the lecture. Like I mentioned, post the Justice Puttaswamy judgment, we have the Justice Shri Krishna Committee, which was established to study the different aspects of personal data protection in India and how it should be regulated. What also happened was in the Justice Puttaswamy judgment, which recognized privacy or expressly recognized right to privacy as a fundamental right, also in some way said that the framework that we have in India at the moment in terms of privacy is not robust enough. So the judgment goes on to recognize that what we have in India at the moment is piecemeal and there is a need of an overarching privacy framework. Why I bring this up here is that although the privacy law development in India has been slow, but it is an eventuality because of these two things. The right to privacy is a fundamental right in India, and also the judgment clearly recognizes that there is a need of an overarching privacy law in India. So we, as an output, the Justice Shri Krishna Committee came out with a draft privacy law in 2018, and this draft version was available for public consultation and also came out with reports in terms of what the committee saw as its understanding of the situation and what aspects should the lawmakers should keep in mind while further developing this law. This process, this legislation went through the public consultation process. The discussions went on for a very long time. And in December 2019, during the winter session of the Parliament in India, we had the Personal Data Protection Bill 2009 tabled in the Parliament. But as soon as it was tabled, it was referred to a joint parliamentary committee. So the joint parliamentary committee, which is chaired by Srimati Meenakshi Lekhi, is presently reviewing the bill in its current state and what changes need to be made in the bill. The Joint Parliamentary Committee had also held a public consultation exercise. So the public consultation exercise, a lot of law schools, trade associations, private organizations, Indian, US, global organizations, even the European Commission also participate in the public consultation process, and they send in their inputs as to what they believe are the positives and certain drawbacks of the bill. The Joint Parliamentary Committee reviewed all these submissions and they have been calling specific stakeholders to come and depose before the Joint Parliamentary Committee and in person giving their account of what is good and what is bad and what needs to be changed in the bill. As of very recently, we saw that the Joint Parliamentary Committee, although it was supposed to submit the report in 2020, December, but largely what we hear is that we will see this getting pushed to the budget session in 2021. So that is sometime around March, early April. With this, I'll start the actual meat and bones of the discussion in terms of the legislation that we have. I'll try to simplify it as much as possible. I'll try to, it is an incredibly legal area of deliberation, but I'll try to contextualize it for all of you to make sure that you understand basically, what these things actually translate into. So what we have in India at the moment is, before getting into that, like I mentioned, this whole conversation around what essentially is data privacy and what is information privacy and when do these legislations become important. So this is taking from the Personal Data Protection Bill and sort of the sphere of regulation that we see around such data. If I were to take data as a whole thing, imagine it as a larger circle. Within this circle, there is a smaller circle, which is known as personal data. So personal data essentially is any data which is related to a natural or a living natural person. So a natural person is a human being. So any data which is associated with a human being. This data could be something which may be used to identify an individual directly. Say, for example, my passport, right? If you look at my passport, you will be able to say this is this Anand Krishna. I mean, India is full of a lot of Anand Krishnans. Privacy comes to the picture when we have a piece of information or data which is able to single out a person. So by looking at my passport, you would be able to distinguish me from other Anand Krishnans that may be there in India. So that document itself was enough to identify who I am. This is essentially the sort of what we had, or is the less vague part of the discussion. When the vagueness actually comes into the discussion of personal data is when we talk about the growth of computational power and interaction with different kinds of databases and different string elements of data. For example, now you may identify me by just looking at my passport, my Aadhaar, etc., etc., or you may able to create a profile by piecing together different information about me. So you go to my LinkedIn, you're able to find out, so this is Anand, his name is Anand Krishna, and he works here at Data Security Council of India. You have some other source of information that you've collected from which you are able to gather how old I am, how much I weigh, and other things, and etc. etc. These different pieces of information which could be combined together to identify Anand Krishna. So one is pieces of information just on the basis of which, like a passport, you are able to identify somebody, or different pieces of information about an individual you are able to combine to identify somebody. This is known as personal data. Personal data, any sort of privacy legislation comes into the picture only when we are dealing with personal data. That is the core fundamental ground on which we will build now. So we have personal data. But we also see that there is a lot of information which is very central to an individual's identity, right? And it is of incredible importance in how we as individuals interact in society. This could be information such as, say, in the Indian context, your religious information, caste, tribe, these kind of information which may lead to, if misused, could potentially have some sort of harm befall the individual. This kind of information is categorized as sensitive personal data. Okay, why I bring up sensitive personal data? Because in any sort of privacy law globally, you will see, if you compare it with GDPR, this is referred to as special categories of data. This kind of data essentially requires differential compliance requirements. It requires differential levels of protection that need to be given to the data. Say, for example, there is a compliance requirement known as data protection impact assessment. If an organization is dealing with sensitive data, then it definitely would require to conduct a data protection impact assessment, because it is high risk data, because the risk of harm to the individual is high. Different kinds of data that is classified as sensitive in nature. I would take the example of what is given in the Indian privacy law at the moment is your health data, your biometric information, your genetic data, your caste, religious, your information related to your sex life, your sexual orientation, and transgender status. So all of these things have been considered as sensitive information in the Indian context. But the Indian privacy law goes a step further, and it says that there is, this is a 2019 version of the law, And it says within this bucket of personal data or sensitive personal data, there is another category which is critical personal data. Now, critical personal data is something which has not been defined under the Indian privacy law, and we really do not see this category in other privacy laws globally. Critical personal data, from what we understand in our conversations with the government, is something which could be considered critical from a national security or national interest perspective. Information related to army personnel, information related to military bases, and personal data of the individuals stated within said military bases could be one example. But the law doesn't define it. It just says that government later on may categorize something as critical personal data. And what happens if something is categorized as critical personal data? This is something that I would urge all of you to also explore as an area of, this is essentially known as trans-border data flows or cross-border data flows. I mean, we talk about how transfer of data essentially is one of the ways which has accelerated digitization and digital transformation in India and globally. Critical personal data, if something is categorized as critical personal data, then it would have to be localized, stored in a data center in India alone. Okay? And it cannot be transferred outside. So it has a lot of consequences for organizations that store their data in servers outside India. It has essentially been introduced into the law to compel organizations to store the data within the territory of the country. Okay. Now the law also talks about another category of data, which essentially the law only applies to these three categories of data that I'll mention: personal, sensitive, and critical. But there is one provision in the law which talks about non-personal data as well. So the way that I will define, so think about it. So now if we take personal data, let's say personal data, and we've seen that personal data is a larger bucket. So when I say personal data, I am saying it inclusive of sensitive as well as critical data. Once this data goes through the process of anonymization or removal of these identifiers, then it would become something known as anonymized personal data, or some may say that is actually an oxymoron, because if something is anonymized, then it ceases to be personal data because you're removing the identifiers which are associated with it. But that's just how the law has labeled it, hence I'm using the same terminology. This will go into a larger bucket, which is known as non-personal data. And you must have been seeing in the news a lot that there is a lot of deliberation around the non-personal data utilization in India, how non-personal data is to be regulated in India. So Section 91 of the Personal Data Protection Bill 2019 says that the government may ask, essentially not ask, may direct an organization to give up that non-personal data or anonymized data and share it with the government, and the government may use it for say evidence-based policy research and other public policy initiatives. It's been very widely worded at the moment, but I just to avoid confusing you guys, and I know that this is confusing enough, I don't want to add that dimension, but this is what essentially the law says. It covers personal data as a whole, applies to personal data, sensitive personal data, and critical personal data. And the only exception is non-personal data under Section 91 of the bill. Now, coming to what we have in India right now, and I think some of you may have heard of it. So there is something called the IT Act. This is the IT Act, the Information Technology Act, which went through an amendment in 2008. and we had two specific provisions which were added into the law. There was section 43A and section 72A. Both of them talk about personal data protection in India. That is the landscape that is there in India at the moment. So it is IT Act and these two main provisions, that is section 43A and 72A. Okay. The major difference that I wanted to sort of highlight here and mention here is the current framework in India that is there, that flows through section 43A, only applies to private organizations and companies. It doesn't apply to the government. That is one of the major changes that we will see when the privacy law comes in India, or the privacy bill that is there, the 2019 version. It applies horizontally to the government as well as private organizations. But currently, section 43A that's there, the framework in India at the moment only applies to private organizations, and it only applies to sensitive personal data. So it doesn't apply to personal data as a whole, but only this sensitive personal data, the smaller subset that exists between personal data. So virtually not giving any sort of protection to personal data in India. And this is why, one of the reasons why the Supreme Court judgment said that the framework that we have in India at the moment is not sufficient to protect the privacy of the individuals. Okay. So what happened in what happened was, if you can see, section 43A says that an organization is negligent in implementing and maintaining reasonable security practices and procedures. So the question was, what are these reasonable security practices and procedures? So these are also, well known as SPDI rules, or sensitive personal data or information rules. So these were notified in 2011. Okay, if you do a quick search, they should come up. This is a set of 8 rules which sort of formulate what is the current privacy framework in India. Just 8 rules. And again, going back to what I'm saying, that it is not comprehensive enough in terms of dealing with the protection of privacy for Indians and protection of privacy in India. Now the question should be that then what is the sensitive information that you talk about, and what is there in the existing framework at the moment? Presently in India, this is the kind of information which has been classified as sensitive, right? Password is something which has been classified as, and this is something which is a major matter of debate globally. Why would you categorize password as, sensitive information? If you go back to what I was saying earlier on, it is very much associated with the identity of the individual and information which is very personal, which is close to the individual, and there could be potential ostracization or some sort of harm that may come to the individual if the information is misused. And we see password as something which is a bit out of place, because as a security measure, definitely important. Is it confidential information, but is it sensitive? And sensitivity is a different lens through which data needs to be examined. Financial information, physical, physiological information, medical health conditions, records, biometric data, etc. So these are the kind of things that have been classified as sensitive information in the current framework. That is the Reasonable Security Practices and Procedures of Personal Data Rules, 2011. Privacy principles, there are general privacy principles that you must have heard of. A lot of things that get thrown around and everybody must have heard of it is notice and consent. Excuse me. So that's what, having a privacy policy is one of the ways in which you will notify somebody. So notification generally means that, hey, look, this is the data that I'm going to collect about you, and this is the data and how I'm going to utilize that data and what kind of data I'm collecting, And if there is any sort of grievances, this is the person or this is the office that you should reach out to. So that is the kind of disclaimer that you give. Consent is an affirmative action which is given by an individual to communicate their willingness to allow processing of data. So how it is manifested is through clicking boxes, radial buttons. It could be a written declaratory statement. I could, over the phone, I could say that I consent to this thing. So that's how generally consent will be utilized. And there are other principles such as limiting the collection of data and use of the data for what is necessary. I'll just give you a small example of this. I mean, we've seen these dodgy applications. Like there was one I came across was a torch, and this torch sent a torch. Have one wanting access to say my camera. I understand because it needs access to my flashlight, etc. But why would a torchlight need access to my, say, location data, my phone numbers and my contacts, etc.? This is a very classic example of not limiting collection of data to what is necessary. What did I need this torch application for? Was just to sort of to exercise just the basic functions of a torch, not anything else. And we see that the data collected or data asked from us was more than that. Retention. So retention is that you can only retain data for a specific time, and all of these other rights that also go there in terms of, you can ask the organization to correct your information, etc. Grievance addressal is also an important part of this equation. Reasonable security practice and procedures. So it doesn't really go into that much detail in terms of what you are required to do. One thing that it definitely says is that you as an organization can implement ISO 27001, and it will be seen as a reflection of you having implemented reasonable security practices and procedures. But the important thing is, and those who are familiar with some sort of compliance language, essentially is that the ISO 27001 would have to be implemented with the scope of dealing with sensitive data. So having sensitive data as one of the scopes around which you have implemented the security operational controls would be important. There was another requirement which is already there, which exists at the moment, is that you will have to conduct an audit once a year approved by a government approved auditor. Till date, no auditor has been approved by the government. So, I mean, that's another major glaring hole. So one of the things that, comes with any sort of law essentially is how stringent is the implementation of the law. And we've seen under the SPDI rules, the implementation hasn't really been that stringent. The other things that it mentions is that what kind of compensation can be given to an individual, and unlimited amount of compensation can be given to an individual under this legislation. Few other questions that should come up, and it was only a set of 8 rules which were mentioned, and a lot of things were unsaid, so they had to issue a clarification. I mean the government, that is the Ministry of Electronics and Information Technology, METI, if you are familiar. So what are these basic questions, right? The basic questions were, say, what happens if it is an organization which is outside India, right? Would it apply to somebody, say, an organization in the US? The answer was no. It is only applicable to an organization which is within the territory of India. This is very important when we discuss the Personal Data Protection Bill at a later stage. The second question was, what are the fundamental concepts that we should also keep in mind between when we study privacy and privacy laws is there are 2 main concepts. There is a data controller and there is a data processor. So think of it as a client service provider relationship. Do these laws apply in the same level to all of these different players within the ecosystem? The answer is no, that they apply differentially. A large amount of the compliance requirements would be for somebody who is in a data controller capacity, not the data processor capacity. Okay. The other question that usually gets asked is whose information are we protecting, whose sensitive data is being discussed here? It is the sensitive personal data of an individual. Why I say this? Because generally we get this question, and there is a so when we come and we talk to individuals from a security background, and then they sort of compare it with confidential information or corporate IPR related information. Privacy law doesn't protect your corporate or IPR related information. It doesn't protect trade secrets. It protects sensitive information of human beings. Okay. Now, the final thing, like I mentioned, it only applies to personal data or information. Sure. Now we will move to the personal data protection bill that we have presently that has been existing in India. I'll pause here and I'll take maybe a couple of questions. I see a lot of questions. If there is a specific question, if you look at the privacy, so PII is another way of sort of it's kind of the same thing in terms of personal data. It is how a specific legislation or compliance requirements or a specific law is the nomenclature around it. But personal data, PII, these kind of terms are generally used interchangeably. In terms of, so there are several questions. In the interest of time, I'll take say one more, then I'll try to take them later on. I'll try to answer them later on. I think we are running a bit behind. This is a very good question that I wanted to take. Is data protection and privacy, is that the same thing? So, sure, if I mean, this is something that I talked about earlier on as well. Data protection comes into the picture, as the name suggests, when we are talking about data, and specifically personal data. Privacy, on the other hand, is a wider concept in which we could be talking about, somebody looking, say snooping in your home, or they have placed a bug inside your house, or they try to enter your house at some point, which is you did not invite them into your house. There is a wider concept in terms of privacy, which looks at territorial privacy, communication privacy, but data protection is a subset of a larger concept, which is privacy. You will see a lot of conversations in terms of legislations largely talking about data protection or personal data protection, a smaller circle within the privacy. It does not mean that privacy as a whole is not protected. In India, privacy as a whole, as a wider concept, is protected as the constitutional right to privacy. Now, coming to the Personal Data Protection Bill, now there are a couple of terms that I mentioned earlier on that were data controller and data processor, and data principal. Generally the terms that are used are controller and data subject, right? So data controller is an organization that is essentially in control of processing that data or how that data is processed. And whose data is processed is known as a data subject, okay? But in the Indian law, what they did was, they wanted to place the individual at the heart of the law. And because of that, they decided to sort of reformulate how we look at an individual and say that the individual is at the heart of the law, and he or she will be seen as a data principal. And the data controller is an organization that holds the data or processes the data of a data principal in a fiduciary capacity, in a capacity of trust and responsibility. Hence, there was a reframing of the nomenclature. And so when you read the law, you will see, data controller referred to as data fiduciary, and the data subject will be referred to as data principal. So don't get confused about this reformulation. So this is why this had been done, to emphasize greater trust and accountability between the organization. Now, to whom does the law apply? Or how does the law apply, rather, excuse me. You remember what I said earlier on in terms of the personal data protection law, the SPDI rules, only applying to an organization which is within the territory of India, right? In case of the Personal Data Protection Bill 2019, as it currently stands, it applies to organizations that are within the territory of India and also to organizations which are outside the territory of India, but are specifically systematically offering services to individuals who are within India. So a good example of this is, so territorial, you understand, so any organization who is having an establishment in India, the government as well, that are processing the data of an individual, personal data of an individual, then the law applies. It's very straightforward, easy to understand. Now, in case of extraterritorial application, let's take the example of, say, there is a e-commerce company, and e-commerce company which doesn't have any sort of physical office or establishment in India. It is operating out of the US or some other, let's say US for convenience. And they are offering goods and services in India, right? Although they don't have a physical presence in India, but they are systematically offering goods and services to people who are within the territory of India, then the privacy law will apply to them. How it will be enforced is another conversation altogether. The other thing that I want to highlight here was, so one is offering goods and services, right? So there is an active business, relationship which is being established. But there could be other instances where there is not an active business relationship between the two, but the data is being used for the creation of some kind of profile, right? Any activity which involves profiling of data principles within the territory of India. If you've been following the news, say, I think this came out last month, there was a firm, a China-based firm, which was creating profiles of eminent Indian personalities, right, who were within the territory of India. They weren't really offering any sort of goods and services in India, right? But they were creating these profiles of individuals. If the Indian privacy law in this form was applicable, then that firm would have to comply with the privacy law because of this such profiling activity. Now so we've talked about somebody who is, in both of these instances, the personal data that is being processed is of an Indian resident. So I say resident because because it is not just a citizen, it is anybody, or say even a foreign person who is within India. So in both these instances, the person is within the territory of India. But there is another situation that is generally the kind of data processing that we see in India, is that, say, again, let's take the example of US, right? The individual is a US resident, stays within US, right? But their data is being sent to India to be processed, which is a very real situation, right? That's the IT BPM and the GCC, that's the Global Capability Analytics Centers, that perform intelligence on top of data. All of such operations process foreign person's data who is not within India, right? So de facto, the Indian privacy law applies to such kind of data processing. But the central government has a power that it may by notification exempt such processing activity. Why is this even being thought of is something that you should ask. And the answer is that there could be situations where, let's scratch US for a second, if this data was coming from European Union, right? So the applicable law would be EU GDPR. So there could be an instance where on the same kind of data processing, GDPR as well as the Indian privacy law is operating, right? So in such situation, to sort of deal with such situations to some level, this sort of exemption provision has been added. I don't have the time at the moment to get into the pros and cons of what this is. Maybe I can take it later on in the last 10 minutes of the discussion as Q&A. But that's a complete different discussion altogether. It has a lot of public policy importance, issues of public policy importance as well. Now coming to personal data and how it's been defined, so I've already mentioned that personal data is the data related to a natural person who can be directly identified or indirectly identified. So directly identified is with a piece of information like a passport. You just see my passport, you're able to tell this is this Anand Krishnan separate from other Anand Krishnans in India. Other is indirectly, that is through combining different traits and characteristics and information that you've collected about me, piece it together to create a profile or to single out that this is this person. The other thing that it mentions is anonymized data is not personal. This is something that I wanted to sort of bring up here. Anonymization and de-identification is an area in which I would want the community that I am talking to right now to get really involved in, or sort of take notice of at least. Anonymization is going to be an up and coming area when it comes to privacy technologies and privacy product development. How do we de-identify data and how do we anonymize data is going to be a matter of a lot of debate moving forward, because there are a lot of conversations around is it even possible to completely anonymize data to some level. Some say that with enough time you could potentially re-identify information. So anonymization, could it really be said that anonymization is an irreversible process? So that's another area of research that I want to throw to the community. Why is it not personal data? Because what I said earlier on is that it is essentially personal data is these different specific identifiers which are linked to an individual. And anonymization is a process through which you delete or irreversibly remove, irreversibly remove these identifiers from this data. This is something that in the interest of time I'll skip. So this is the different changes that I've mentioned. One of the questions that I saw earlier on, why financial data has been added as sensitive information. There are sort of debates around it in terms of a large segment believes that sensitive data, financial data per se should not be seen as sensitive information. If you look at identity related information, while the others say that financial data could be misused to bring some sort of harm to an individual. So arguments can be made either way. Financial data, so I'll skip this portion. What I'll come to is the different, so you can't just process data willy-nilly, right? There needs to be different grounds under which you are going to be able to process data. These grounds under the Personal Data Protection Bill are these. Consent of the individual. So consent here means the informed consent. It is not just the individual saying, hey, I've agreed to this kind of processing activity. It is informed consent. So the individual needs to be given a notice. The individual, through their consent, recognizes that they have read the notice and they are okay with this processing activity. Second is, and so consent is one ground, and the other grounds that are given here, function of state, etc., are situations where the individual's consent is not needed. Even in the absence of the individual's consent, the data can be processed. And these situations are function of state. The function of state is, say, the central or the state government wants to process your data to provide you access to certain government schemes, welfare schemes. If they wish to provide you access to e-governance services such as issuance of certificates, licenses, challans, etc. So all of this falls under the function of state. So the government need not take a consent to process this data. Second instance is compliance with law and order. If there is a law which requires, so there is an anti-money laundering check. So in case of an anti-money laundering check I need to perform, I'm not going to, or even in in case of payments, there are certain instances, certain transactions that needs the requirement. There's a requirement of Interpol verifications of transactions in the individuals. In such instances, I have been statutorily required to process this information. I'm not going to take the consent of the individual to process this information. I could just use this ground. Prompt action in case of emergencies. So this is, if you're familiar with GDPR, then prompt action is something which is close to vital interest. Vital interest as a ground is essentially in case of when an individual is facing a life or death situation, health emergencies where the individual is not even in a situation or a capacity to give consent. The other aspect of prompt action in case of emergencies is in case of public health crisis. In case of a public health crisis, I may need to process the information of an individual, and for the greater good, I may not take the individual's consent and use this ground to process information. This ground essentially is a better word, maybe it will help you understand it better. Let's say is justification, right? It's a justification as to why am I process this data. It is justification as well as the boundary based on which the government or an organization may process your data. There is a separate ground which is there, which is purposes related to employment. So the purposes related to employment are essentially, there is the fundamental concept of consent is that consent needs to be given freely. So both the parties in this consensual data processing both need to be on the same level. If you look at an employee and an employer relationship, there is an imbalance of power between the two, with the employer always having the edge over the employee. That is why it is generally seen and accepted as a principle that an employee's consent in such situations is not seen as valid, because there is an imbalance of power and there could be a potential element of coercion. If I don't sign the document, if I don't give the consent, I won't get the job. I mean, so it's not really something that can be seen as freely given. That is why there is another ground which is known as purposes related to employment. Reasonable purposes for data fiduciary. So reasonable purpose is a ground. If you're familiar with GDPR, again, I'll draw parallels, is the ground which is known as legitimate interest. What is reasonable purpose? Is there could be certain conditions which require that my interest as an organization, for my interest as an organization, I will need to do certain things and for which I will not take consent. A classic example of this is putting up of video cameras in your organization for security purposes. Right? So in your public areas, within your campuses, you will see that they will have, different cameras which have been situated in certain public areas. That is a reasonable purpose. That is a legitimate interest of an organization to protect the uh, the the individuals within the specific campus, to protect the say or for the physical security within the organization, that it is necessary to put cameras and surveillance measures that will come under a reasonable purpose. All of these grounds are only available for processing of personal data. Sensitive data, on the other hand, which is a smaller subset within larger set of personal data, can only be processed if the individual gives their consent explicitly. How is explicit consent different from just plain consent? Explicit consent has to be nothing short of a written declaratory statement. It is a step higher than basic consent, which will be notification and just taking the consent. How explicit consent is also exercised differs. So generally the regulatory authority that is there, in case of privacy, it's usually the Privacy Commissioner's Office, or in case of the Privacy Bill, we see that this is an authority known as the Data Protection Authority. The Data Protection Authority will come out with something which is known as Code of Conduct, that is under clause 50 of the legislation. So they will come out with different ways in which explicit consent can actually be taken, so acceptable activities. So when this law comes in, there are certain practices that will have to be revitalized from a privacy perspective. One of the major ones is, you must have seen a lot of this, when we sort of access web applications and mobile applications, you see pre-ticked boxes, right? So my consent is assumed, that, and I need to go back and opt out. Hey, look, I don't want to receive your newsletter, and I sort of, opt out of that service. But the boxes have already been ticked. Practices like that are no longer seen as in the intention or in the interest or in good faith of the user. So such practices will have to be weeded out, and the individual will have to give consent for specific processing of their data. In terms of rights, so there are different rights that have been mentioned under the legislation. So these are the basic rights that are there. Confirmation and access. Confirmation and access is that an individual should be able to reach out to an organization and ask them, hey, do you have my data or not? And I should have access to that data. In case of GDPR, it is a bit wider. It also extends to, in case of automated decision making, an individual can also reach out to an organization and ask them, what is the logic behind this automated decision in case of, let's say, credit scoring, right? I mean, your credit score has been rejected. So under GDPR, an individual can reach out to the organization and ask them, hey, what was the logic or the algorithmic logic behind me getting rejected from, say, let's say, a loan process? That has not been incorporated under the Indian law. It is only with respect to access to the data and confirmation. Portability. So portability as a right is sort of fuses privacy and competition. So competition as a concept is, there should be a thriving market and preventing vendor locking. So we've seen examples of portability in the telecom sector with, say, you being able to port your number from one service provider to another service provider. So now imagine you being able to port your data from, let's say, Twitter to Mastodon, right? So one complete set of information, being able to move from one service provider to another digital service provider. There are a lot of, let's say, there's a big asterisk attached to it. An organization can say no to a data portability right. The data portability right can be said, could be rejected on the basis of if sharing of such data with another organization in some way would harm the IP of the organization, then the organization may reject it. The other ground could be impossibility. The cost is too high. I cannot possibly do this because I've had this customer for, let's say, 25 years, and the data just runs into crazy numbers, and it is not possible for us to move the data in its entirety. Right to be forgotten, I don't have enough time to get into the nuances, so I'll just tell you what is there in the Indian law at the moment. In the Indian law, right to be forgotten is that an individual will approach the data protection authority and say that, hey, look, this is this data which is being processed about me by this organization. I would like them to stop processing it now. So the data protection authority would do the assessment and would direct a specific organization to restrict processing of that data any further. They'll stop it. They would have to stop it. Correction and erasure, that's self-explanatory, so I won't really get into detail. Correct the data and also delete that specific piece of data. There are different compliance requirements that are there under the legislation. There are different kinds of players which have been mentioned in the legislation. So there is the fiduciaries can be divided largely. So fiduciary is the main entity which is processing the individual's personal data. Right? It can be further divided into two. These are significant data fiduciaries and guardian data fiduciaries. So what the Data Protection Authority would do is that the Data Protection Authority will have a look at the volume of personal data that an organization is processing, sensitivity of information, turnover, how big the organization is, etc., based on which it may classify an organization as significant data fiduciary. Once it is classified as significant data fiduciary, you will have to do certain kinds of things, such as conduct impact assessments, etc., etc. Every data fiduciary would be required to do certain things, such as have a privacy by design policy, grievance addresser, security safeguards, and report breaches. The minimum thing that minimum amount of transparency, accountability requirements that are there in the law are with respect to a data processor. So a data processor is only required to have security safeguards in place and get an authorization from the fiduciary to allow sub-processing. So this is essentially, say, there's an organization A, an organization B has asked organization B to provide a specific service, let's process my data, and then organization B is like, I'll subcontract it to organization C. So before B is able to ask or onboard C, it will get the prior approval of A as an organization and move on. Guardian fiduciary is a very novel concept. So guardian data fiduciary is if there is an organization which operates commercial websites or provides targeted services towards children, so something like a Baiju, there are certain Disney applications which are specifically run for children, any sort of application which is run specifically for children or targeted towards children. Now, this is the catch here. In globally, we've seen that the definition of what is a child or who is a child is has varied. So, and the GDPR, it is anybody under the age of 16. In US COPA, it is anybody under the age of 13. But the Indian law, anybody under the age of 18 will be considered as a child. So the age gate for your applications and etc. would have to be, normally we've seen age gates. I'll take the example of TikTok and other applications. Age gate used to be 17. So such age gates for products would have to be changed to 18. That's what I see. You will be barred from, if you are a guardian fiduciary, you cannot have targeted advertising towards children and other things. Now, in terms of the data flows, I'll close with this and take questions. personal data can be transferred outside India, but there are certain conditions under which it can be transferred. Excuse me. So personal data can be transferred without any sort of restriction. So it's larger bucket personal data can be transferred outside India. If it is sensitive personal data can only be transferred outside India if some portion of it is going to be mirrored within India. Only then it can be transferred outside India. There are certain conditions that need to be met. These conditions are having an adequacy decision or having standard contracts in place on adequacy decision. Only then the data can be transferred in India. And what I mentioned earlier on, if something is classified as critical, then it cannot be transferred outside India. It will have to remain localized or stored within a data center within India alone. There are certain exceptions that are there in case of, say, medical health services and emergency services. In such situations, data can be transferred, or if the government has approved the transfer of data. Okay, so I'll stop here. From this point, we can take questions. If you have any time left, I think I've overrun.
Thank you, Mr. Krishnan. Yes, we are right on time. We can have 5 more minutes, given that the lecture has ended, for questions. And I have already gathered some. So if you're ready, I can start repeating them.
Sure.
So there were a lot of questions about anonymized data, and especially regarding, well, can anonymized data be de-anonymized, and in particular with relation to national agencies and the government?
Okay, so I'll take this in 2 parts. One is that anonymized data, if it is re-identified, if there is a possibility of it being re-identified, then it can't really be called anonymized data. It needs to be a completely irreversible process. And I understand, I mean, this is something that I mentioned earlier on as well. Anonymization is not an absolute concept if I were to look from the lens of research. But from a legislation point of view, a legislation needs to draw its boundaries to some level as to what can it actually regulate or not. So anonymization is always to a degree, and this degree and the techniques of anonymization would qualify as you know, ones that can be used to anonymize data would be defined by the Data Protection Authority. So anonymization is irreversible to the extent which has been defined by an authority. So there could be different ways of doing it. There could be a risk of re-identification. That's one approach. Say CNIL, that's the French regulator, follows an approach there. There is a risk assessment of, let's say, this data is safe, 99%, 98% safe from any sort of re-identification of data. What the law does, though, is gives protection in terms of criminal penalties. So if there is any sort of re-identification of data, then the individual can go to jail. So it's a very we generally don't see it in privacy laws. Privacy laws usually talk about compensation provisions, but such as the protection given to anonymization, it is seen as if it is re-identified, individual can go to jail. In terms of law enforcement agencies and national security, de-anonymization, that is a very good question, and this is something which has been debated a lot. There is a long section, this is along the segment under the law which is dealing with exemptions. And this is where the law has run into a lot of debate in India as well. There is a situation that a law enforcement, let's say, not law enforcement in general, but national security agency may ask for a complete exemption from the application of the privacy law. There is a possibilities of that, you know, all these things that we've talked about won't really apply to a national security agencies. Having said that, they would have to be regulated by the due process that exists in other legislation when it comes to national security. Yeah.
Thank you, Mr. Krishnan. Another question that may be related to this is, well, during the coronavirus pandemic, for example, did the Ministry of Health or other national agencies recorded and collected personal data? And do you know how they handled them and if this was in line with privacy law in India?
So this was done completely in the absence of a privacy legislation in India. And if you go to what I said earlier on, where the SPDI rules and the IT Act provisions only apply to private organizations, it doesn't apply to the government. So the government, I wouldn't say did operate in legal vacuum at the moment, but the larger protections were there in case of, let's say, right to privacy of an individual is a constitutional right. The state still needs to uphold the right to privacy. But again, any sort of right is not subject to any exemptions. And in this scenario, the government would have been able to make the exemption that this is for a public good, that such utilization of data is being done. But certain guarantees were given by the government in terms of the protocols that would be followed. So there is contact tracing guidances which came out as to what and how, to whom the data would be shared within the organization. If you look at the other Arogya Setu app, which was the Indian contact tracing app, it also clearly mentions as to which kind of authorities with whom the data is going to be shared and with whom the data will not be shared. And that data will only be shared in an aggregated form, never in its personal identifiable form.
Thank you. And maybe last question regarding your last slide, which is the transfer of personal data internationally. What's the difference between sensitive personal data and critical personal data?
So the critical personal data, so let's start with sensitive personal data. So sensitive personal data is an exhaustive list of elements or data traits which are laid down in the legislation. So the Indian Privacy Bill, like I mentioned earlier on, it is financial information, it is health information, it's biometric information, caste, tribe, sexual orientation, sex life, transgender status, and all of these things. So specifically, these things are classified as sensitive. So it has clearly been defined in the legislation. Critical personal data is something which has not been defined in the law. It is pretty vague. The central government, by notification, that's a gazette notification, can come out and say that this can be considered in the future as critical personal data. Although sensitive personal data has other compliance requirements associated with it, like I mentioned, in terms of only explicit consent, data protection impact assessment, critical personal data has only been introduced in the law to implement localization or data residency in India. There is no other objective which is there. It is national security and strategic interest, the reasons for which the data is going to be localized in India. That is a general difference.
I think, well, we are over our time. So if you would like to make any closing remarks, there's a lot of interest on your lecture and certainly many questions. So if you could provide also channels for communication and yeah.
Information we sort of make available in the public domain. So you can find it on the DSCI website, that is dsci.in. You go to the privacy section under the personal data protection framework for India. So all of the slides I usually upload there, so they're available in public. We also run a few certification programs which go a little more in depth in terms of privacy. So that's another avenue in terms of trainings, etc., etc. But publicly available information is there on our website, and I'll be more than happy to share this reading material with you to circulate with the attendees.
Thank you so much, Mr. Krishnan. Yes, if you share, I will share with the entities as well. Thank you for your support and your time today. And with your lecture, we conclude today's lectures. Just